I am about to interpret a criminal case, but before we get to that, let me take you on a brief tour of my past to show you my limits in criminal law education. When I graduated from high school, I was facing an intricate choice for a profession. I had to select between a physician and a musician, as I also had graduated from a 7-year school of music parallel to my high school, and I was pretty fond of music. My father said clarity that I do not need to earn a degree in music to be a musician, that I already was a musician because I could masterfully play fortepiano to compose, and I knew solfege very well. As he said then, play fortepiano at the family dinner and practice medicine for bread. So I became a medical doctor, per the family traditions, as both my parents were in the medical field. I earned my MD degree at age 22 and started working as an independent physician at age 24. Those are facts. I got my PhD at age 33. Besides, I studied at 9 other universities for non-degree or postdoc programs in public health and advanced research methods in psychology. In 2001, I also carried out case studies for the IPPF Belgium, the Brussels office, but frankly, as a conservative woman, I disagreed with the IPPF mission. It was then that I developed an interest to contribute to reproductive health law, specifically in raising awareness of maternal-fetal conflicts. As a moderate conservative, I admit that there are extreme circumstances where abortion is warranted, but I do find that reasons for termination of pregnancy must be medical or legal, neither socioeconomic nor psychological, nor based on a blatant choice with no reasoning. I am neither a Democrat nor a Republican. I am a technocrat, but I believe that Roe v. Wade should stay. It should not be reversed and should not divide the nation either. It is a comprehensive law with careful language that sets balancing tests based on trimesters, whereby during the 3rd trimester, abortion should be banned entirely unless there are exceptions for the necessity to save the mother's life. Although Roe v. Wade has been weakened by some rulings and statutes, I believe that we do not need to repeal it. Rather, we need to update our definitions of a trimester, leaving Roe v. Wade as it is. You may know that after the Beijing Conference of 1995, the definition of fetal viability was updated and the liability threshold was shifted to the left from the 28th gestation week to 22nd. Below you see the fetal measures during both weeks. It is also crucial to understand that abortion is a maternal-fetal conflict, but not the only one. Smoking or using illicit drugs during pregnancy, vegan diet during pregnancy, texting while driving during pregnancy are types of maternal-fetal conflicts that involve negligence or moral turpitude. To raise awareness about this issue, I put some efforts, such as opening a website that I named RELINA, an acronym for Reproductive Health Ethics and Law in Action, now closed. I opened a social blog with salon.org and even tried to open my journal on a biomedical platform, which didn't happen because I was required to collect 24 manuscript submissions within a month to be able to open a journal, and there were not enough scholars who were willing to contribute in a short 1-month period. So I wrote articles and books in law and healthcare law before even studying at law school. My publications related to legal issues are listed on the following 2 slides. In my mid-40s, I decided to earn a law degree to make my voice better heard. As I never intended to become a practicing lawyer, I pursued a Juris Master's degree. In fall 2013, I was admitted by Emory Law. The tuition was quite high for a master's degree when I was unemployed at that time. I deferred my studies for a year, looking for alternative and cheaper options for a similar degree in law. During that year of deferment, I audited, not for credit, a criminal law class at Emory Law. That was before officially studying at Seton Hall Law. At Emory, the criminal law lectures were delivered by an outstanding professor of law whose name I will not share because I haven't asked permission from him. I will only let you guess who it could be. I never skipped a single lecture during that year. After finding a similar degree with lesser tuition, I graduated from Seton Hall School of Law, where I majored in healthcare and hospital law and intellectual property law. I did study torts, though, which includes criminal law, and also medical malpractice law, Stark law, biotechnology law, and much more, as shown in the right column. So all this was to explain my limits in criminal law education, which are a year of audition in a criminal law class at Emory Law, studying doctrines at Seton Hall Law, or when I presided as a moot court judge in DC upon federal crime cases, or did research and publishing. Overall, my journey in legal education started in 2000, when I, an OBGYN doctor interested in reproductive health law, took summer school in legal studies at the Central European University in Budapest. After I explored the issue at Vienna University Hospital in Austria, at the George Washington University in District of Columbia, where I was a regional exchange scholar, as well as at McMaster in Canada. I have certificates in legal studies and a degree in law, master's degree. Back to Emory Law. The first lecture was about the cinder, the criminal intent or mens rea, defined by the Model Penal Code and common law rulings, whereby the severest form of mens rea is the aforethought malice. Over the last decade, I myself have been the victim of aforethought malice and organized crime by a group of villains from Massachusetts, but I will not detail that experience in this video. So, it is 2013 and I am at Emory Law auditing criminal law. During the first lecture, the professor is discussing the necessity to commit a crime as opposed to deliberate or non-aggravated malice. And he introduces the very first case, which is Regina v. Dudley and Stevens. A case that is more subjected to media attention worldwide than it is taught in the law schools of the United States because of its heavy nature, both emotionally and semantically. Regina stands for Queen Victoria. As the monarch was the state and the case was criminal, the Queen was a side. The case is also coded as R. v. Dudley. My problem is with the right wing of the title. The defendant Brooks is missing. This video is mostly about the oddness of the case and my chief arguments presented in slides 10 and 17. Let's fast forward. Things that, to my knowledge, have never been discussed at law schools or by the media. Studying it, you will learn how the status of the third defendant, Brooks, was changed to a state witness to make the trial possible, how the remains of the victim, Parker, were not preserved for evidence, therefore the only evidence was exclusively testimonial. The only witnesses were the defendants themselves, and their right to be silent would impede any formal proceedings. A confession was only admissible against the person making it, not the co-defendants. You will also learn my attitude toward the common purpose or ratio decidendi doctrines. Note that my arguments present my own views. I haven't adopted them from any published source or any law school, including Emory Law. Further, you will learn how the trial judge made the jury render a special verdict on the conclusion of facts and remain ignorant of the culpability verdict, leaving the latter for victorious High Assizes Court to determine, and how the statutory death penalty was changed arbitrarily to 6 months incarceration. Now, starting from here, I will not read my slides, so you will continue this journey on your own.